Now, those of you who are regular readers of Democracy Docket know that Alabama drew a map after the 2020 census with one Black Opportunity District that was challenged. And ultimately, the court held that there needed to be two Black Opportunity Districts. That case went all the way to the U.S. Supreme Court and back down. The three-judge panel said, yep, you got to have two. What did the state of Alabama do? Well, they passed the new map with only one. This is just another example of Republican intransigence in the face of an order. Well, this three-judge panel was hearing none of it. They not only said that Alabama did not comply with their court order, they said, you know what, maybe we will throw you back under the pre-clearance regime. What does that mean? Well, those of you who remember the Shelby County versus Holder decision, it used to be that parts of the country that had histories of racial discrimination in voting, before they could make changes to their election laws, they had to either seek permission from a federal court or from the Department of Justice. And that permission, if it wasn't granted, meant they couldn't change their law. And they had to get that before they made the change. Well, that was struck down by the Supreme Court in Shelby County versus Holder, but it wasn't entirely gutted. There is still a provision for federal courts to bail in states if the state has demonstrated a continued reticence to abide by the voting rights of minority voters, or they continue to intentionally discriminate against voting rights, as the judges in this case found. So Alabama definitely doesn't want that to happen.